Good afternoon, everyone. This is Sean Timmons. I'm the managing partner of our Houston area of operations. I've been an attorney now since 2009, going on year almost 17 in May. Been litigating in private practice for more than 12 years. Been in private practice with Tully Rinckey specifically, doing military law, national security law, RC disenrollments, and other military areas of the law for 9 years. Also been doing federal labor and employment law, USERRA, Title VII litigation, 1981 litigation, and all other areas of both federal and private employment law. So I cover quite a large practice group, basically 4 legs of a horse is how I describe it to people. One leg is military court-martial defense, another leg is military administrative work, such as separation boards and other admin-type military issues. Another leg is service academy representation, ROTC defense, and the other leg is the umbrella of employment law, where I'm licensed in all the federal courts in Texas, actively practicing pro hoc in Virginia, actively licensed in Colorado and New York and other jurisdictions around the country, handling USERRA matters. So I generally handle a wide variety of a docket. I've got quite a number of cases under my direction where I'm the managing attorney, handling about 12 attorneys who report to me on a day-to-day basis, handling the matters. So I appreciate the help and assistance from all the partners and senior counsel and associates and everyone else we have working together on our team. We're a collective team at Tully Rinckey. We all work together. So the unique thing about Tully Rinckey is you're not hiring Joe Smith, attorney at law. You're hiring Tully Rinckey PLLC, which is an 80-plus lawyer firm. No one individual attorney is exclusively assigned. We work together as a team to promote each client's best interests. And as a team, we put together a slideshow today. We're going to go over some issues associated with the changes in policy that's happening from Washington, D.C. throughout the Department of Armed Forces. Obviously, some of these changes are unpopular. Some of the changes probably are very popular. That's not really the intent behind the presentation, is to give an opinion regarding the desirability or lack of suitability for these changes. It's just to describe them to the extent possible as a neutral umpire. As an attorney, I'm hired to represent individuals who may have a case that requires a presentation of evidence, make more one particular point of view, and then I may also represent individuals on the defense side. So one of the things unique about Tully Rinckey is we specialize in helping veterans, but I help veterans in their employment claims at USERRA. I also help veterans when they have a small business and they're defending claims by their employees. So I get to see both sides. I get to appear as a defendant. I get to appear as a plaintiff. I get to appear as an advocate for the accused. I get to also represent interests of those seeking clearances in all sorts of different capacities. So as an attorney, I may have to overlap some of the talking points because they may not all be relevant to everybody's situation. So it's a little confusing, but as an attorney, we're hired to represent clients and advance the client's interest. And some clients' interests may not necessarily match up with the interests of other clients. As long as they don't conflict, though, we're able to coherently represent them to the maximum extent possible. So let's go on to the next slide, the overview. Today's presentation is going to cover a generic description of the executive orders. And we had a presentation a month ago when they first were being rolled out, but since then there's been over 200 additional orders that have been issued by the White House. I encourage everyone to go to whitehouse.gov and click on executive orders, and you can see in written format all of the executive orders as they've been produced by the Office of the White House and issued to the executive agencies. Some of these orders are blocked, some are pending litigation, some are on hold, suspended as a result of TROs. A TRO is a temporary restraining order. Individual judges in district courts and federal courts around the country, many of them have issued what's called TROs, temporary restraining order, limiting the enforceability or enforcement of executive orders pending further litigation and further resolution. Some of those suspensions of the enforcement of the TROs are being litigated in the circuit courts, and I believe some have already made their way up to the Supreme Court for ultimate decision and resolution. Some of that covers operations by the Department of Homeland Security when it comes to the recent deportations. Some involve the transgender ban on members of the military, which is temporarily suspended, and Whether it gets implemented is to be determined in a later time. We'll talk through some of the ramifications if these orders are actually implemented, but as of right now, many of the orders have been published but are on hold pending further litigation in the various courts around the country. It's a little confusing. Quite honestly, it's dizzying because there's hundreds of courts in the country, and an individual federal judge, there's hundreds of them. Some of them have issued what's called nationwide injunctions. So their order from, say, Washington, D.C. covers the entire country, or their order from the Seattle, Washington District Court covers the entire country. Some orders may contradict. That's why the circuit courts have to decide the resolution, and ultimately, if the circuits disagree, the Supreme Court has to get involved. What that means is the United States is divided into many circuit courts. In Texas, we operate in the Fifth Circuit, based in New Orleans. New Orleans Fifth Circuit covers Louisiana, Mississippi, and Texas. So when individual federal judges in individual federal judicial jurisdictions, say in Houston, issue an order, and somebody wants to appeal that order, it goes to the Fifth Circuit in New Orleans. Well, in Virginia, if somebody appeals a decision from, say, the federal court in Richmond, it goes to the Fourth Circuit. The Fourth Circuit may disagree with the Fifth Circuit. If the Fifth Circuit issues a decision that says A is okay, and the Fourth Circuit says A is not okay, ultimately the Supreme Court has to make a decision on which circuit court opinion it'll adopt, or if both are wrong and B is the correct answer. That's a little 100,000-foot overview of the complications associated with litigation. We're going to cover primarily in this presentation the impact on the Army, Navy, Marine Corps, Coast Guard, Space Force, and Commissioner Corps. And as an update, the Navy just issued an immediate action response to social media guidelines, telling the members of the Navy, and this is applicable across the Department of Defense, to be mindful of social media content. As members of the armed forces, you are not allowed to express your political opinion in an official capacity that's partisan, because there's laws that limit your participation actively, openly, while in the status as a member of the military. As a private citizen, you're allowed to vote, you're allowed to go to a campaign rally, you're allowed to have a bumper sticker on your car, you're allowed to do certain limited activities. But when you sign a contract with the military, or you take an oath as a commissioned officer, you agree to restrictions on your First Amendment rights in accordance with military discipline. One of those restrictions is to not engage in what's called partisan political activity. Many members of the military have gotten themselves in trouble for open defiance of presidential orders. There was a lieutenant colonel about 15 years ago who was a birther conspiracy person who believed President Obama was not born in America, therefore his orders were illegitimate. He was prosecuted and ultimately, I believe, forced into a disgraced retirement because he refused to comply with his orders, and he openly mocked the president on social media. That kind of behavior is unlawful. It's completely prohibited, and I would discourage anyone from openly, in a military capacity, using their position in a negative manner. I've represented commanders previously who've been removed for flagrant violations of the social media policy. You, as a citizen, are entitled to post your opinions. As a member of the military, have to be very careful about what you post on social media. That's just the most recent update. Me, as a former member of the military, as a private lawyer in private practice, I can post commentary pretty freely. But if I was part of the military, I would be limited. There's also the articles, I believe 85 through 88, that limit your contempt for officials. You can't openly be contemptuous of leadership. Even if you disagree, you have to maintain good order, discipline, and military bearing. But keep all that in mind as we go through all this. That's just a generic description. And is it lawful for them to prohibit and limit your generally authorized legal rights? Well, the answer is yes. That's why you sign a contractual agreement. The contractual agreement, in exchange for compensation, limits your legal rights to some extent. Not fundamental legal rights, like right to counsel and right to be free from torture or something, but conduct restrictions are permissible. For example, in the military, if you show up late to work, that could be a felony. In the private world, if you don't show up late to work, you can get fired, but you're not going to go to jail. That's the difference between military service and non-military service. We will not cover in this process the updates to the UCMJ. However, there's been substantial updates to the Uniform Code of Military Justice over the last decade. especially when it comes to the prosecution of sexual assaults and the prosecution of other crimes. Some of them have been removed from oversight by the chain of command. That's a whole different webinar topic when it comes to military separations, military reprimands, administrative separations, medical separations. All of that is covered by other webinars that I've provided or other webinars our firm has provided. This is going to cover simply the implementation of current executive orders and the actions associated with the implementation of the current executive orders. We're not, I may throw a few war stories in there and that might overlap with some stuff, but generally we're just going to cover the executive orders that are being produced and some updates to what's happened with them. So let's go on to the next slide. One of the most biggest changes is the elimination of what's considered DEI. The executive order produced on January 27th has generally withstood judicial scrutiny, although it has faced obvious political backlash to some extent with the removal of certain distinguished individuals' credentials from websites. They're using artificial intelligence to scrub certain social media content, and they've announced the review is ongoing, but you'll see a lot of changes to content. For example, the promotion of history months. I believe, there was African American or Black History Month, February, and in March there's another History Month, and in June there's Pride Month, and October there's all kinds of different celebratory months that the Department of Defense would put out there. For example, Pride Month. Years past, people who are identified as having homosexual tendencies were not allowed to join the military. The military changed policies on the Obama administration, openly allowing individuals to serve. The military to recruit would promote Pride Month. The new DEI elimination says promoting Pride Month or any other month such as that is now banned. They're not going to do it. Only that we're going to celebrate is the 4th of July. Everything else is gone. Seems excessive. Arguably, it's an overkill, but that's the intent, to try to get rid of everybody having their own identified month. The intent behind the policy, as published by the Secretary of Defense, was to focus on lethality of the military and unity through mission accomplishment, and not focus on our differences as much as just our single purpose, which is to fight, kill, and destroy the enemy. That's the policy behind it. It's not really subject to too much judicial scrutiny because the military ultimately can decide what or what not to promote and what to, and in your private capacity, you're welcome to join private organizations. So if you want to join the Salvation Army and help homeless, you're more than welcome to do so. And the military made that clear. It's just they're not going to have a specific web page dedicated to that particular cause anymore. They're trying to get rid of advocacy for any individual causes to avoid, to some extent, partisanship, but also to another extent, just to try to remove any promotion of this concept of diversity, equity, and inclusion. Obviously, the military is a diverse force with people from all walks of life and all backgrounds and all socioeconomic characteristics, but it generally tends to be certain categories. A lot of members of the military come from families of members of the military. A lot of members of the military come from rural backgrounds or disadvantaged economic backgrounds. Me personally, that's how I joined, a long time ago. I came from a situation that was complicated, and I made the best of it, and ultimately enlisted and became a JAG later after a break in service. Everybody has a unique story, and there's not really one way to stereotype a member of the military. Everybody's different, and the diversity within the military is a source of pride and strength. However, the current administration wants to focus primarily on restoring lethality, meaning focusing on precision when it comes to combat readiness, and nothing else beyond that. So there was a lot of training on sensitivity for behavioral awareness and being more culturally aware and being more sensitive to gender dynamics. That promotion is now out the window, it appears, and the focus is back to technical capacity when it comes to rifles and tank operations or plane warfighter bombing, stuff like that. So that's the current DEI elimination. Not really much else to say on that. I'm not trying to take sides on this to the extent possible. Just trying to say that's not really something that judicial courts are going to really get involved with. Let's move on to number 6. This is the next one that courts are involved in. And as an update, the removal of individuals who identify as transgender. So the military recently gave everyone an opportunity to self-identify as transgender and receive a automatic honorable discharge. So if you're actively in the military and you don't want to be there, I have a real easy solution for you at the moment. Just identify as transgender and they'll give you an honorable discharge. I've never seen such an opportunity to immediately be released with an active separation for honorable characterization. Never seen it before ever. But at the current moment, right now, this is your opportunity. If you are serving the military with a contract and an ongoing obligation, and you do not wish to continue to serve, and you don't have a problem with identifying as transgender, then you can do so and you'll be given an automatic honorable discharge. I don't know how long that's going to be available because they did say it's going to be limited for a very short duration. Eventually, they're going to go through and notify individuals of failure to be medically suitable for continued service and try to remove them. That's blocked at the current moment by the federal courts, saying that's not the lawful way to do it. And I believe the courts will probably come down on protecting those who've already signed agreements. So if you have an agreement where you've already serving and you have a contract that says you're serving until 2028 and you identify as transgender, that contract's probably enforceable and you'll probably get to continue to serve for the duration of your enlistment because you've already agreed to that term and you were accepted with the condition you had upon the contract. So I think trying to throw people out with new criteria will run afoul of judicial rules, and I believe individuals will have a strong case to continue to serve. The second part of that issue, though, is individuals wishing to join the military will probably face insurmountable obstacles because the selection criteria changes frequently. At certain points during the Iraq War, they allowed individuals with felonies to join in large numbers. Currently, if you have a serious felony, they're likely to tell you you're not eligible. They change the criteria periodically based on what they call manpower needs. So during the Iraq War, when we needed to increase the size of the force, they said, okay, if you have a felony, but it's more than 5 years ago or 10 years ago, we'll consider you for a waiver. Then when the drawdown happened, they said, nope, no felony waivers. So the point behind that is they change the criteria kind of willy-nilly whenever they need to. If they need to increase manpower, they loosen the criteria. If they need to throw people out, they reduce the number of people coming in, they increase the criteria. So that is not something that's really subject to too much judicial intervention. The courts are deferential to the military's selection criteria. In fact, the military, just like national security, when it comes to security clearance, is actually permitted by law to discriminate openly. Sounds kind of backwards, right? Because they shouldn't discriminate, and discrimination should be unlawful, and it is. If you're a regular private employer, you can't discriminate based on protected characteristics. However, the military, being under the national security exception to those statutory protections for discrimination prevention, they're allowed to discriminate to some extent and have selection criteria that's far different than any private employer. So, like for example, if you have a medical obesity or asthma and you apply for a job at Burger King probably can't tell you, sorry, we can't hire you because you have obesity. That would be a violation of the Americans with Disabilities Act. Military, though, can say, sorry, you don't meet the height, weight criteria that we've established. And they can loosen it up, make it allow more pounds, or they can tighten it up and make you required to be thinner as the needs of the service change. So when it comes to eligibility to serve, if you identify as transgender, if you put that down as your identity, they could say, sorry, that's a condition that we are not going to grant a medical waiver for. If you identify that way, you're not eligible for joining. However, if you're already serving, that's a whole different analysis, because if you have more than 6 years of active federal service as an officer or enlisted, you're entitled to a board before you can be removed. And if you acquire the condition after joining, you're entitled to continue treatment, and being arbitrarily thrown out is not something that should be happening, because you should have protections and rights to retention that are available in the regulations. And on a case-by-case basis, individuals will be able to fight their separations. There's currently a full injunction. I don't know if the full injunction will stand or if the courts will allow it. But regardless, if the courts do permit the ban to go into effect, individuals who are currently serving on a case-by-case basis will be eligible to ask for an exception to continue their military service. And if they're close to retirement, you really want to get that retirement. And if you're close to the duration of your honorable characterization, you want to finish out your term if you can. However, if you, at the current moment, there's an amnesty plan, if you identify this way, you're going to be granted an automatic honorable. And I've already seen military lawyers, post on LinkedIn that they, had in their pronouns he, him, or they, them, and they submitted their resignation, and they're starting new jobs soon. So people are already transitioning out of the military under this eligibility criteria. I've seen at least 3 lawyers on LinkedIn that I'm connected with proceed with this process where they're given an honorable discharge and they're moving on to leaving the military. So if you are in that category and you wish to walk away from the military, this is your chance to do so with the least resistance possible. As the courts adjudicate the matter, it's possible that the rules the military implements will be considered lawful. And if that's the case, it may be more difficult to get out cleanly, and it may be more burdensome. So I would look to getting out if you wish to do so, because serving as transgender, at least until the year 2029, and the current administration, looks like it's going to be insurmountable and very difficult. And even if it was permissible, you're going to face hostility from leadership. So I don't know how desirable it would be to serve in an openly hostile workplace. Individuals reinstated after discharge from COVID. That's still in the works, but I had clients over the years who refused to take the COVID vaccine. They were separated. Some of them received honorable separations, some received general separations. Many of them, if they wish to do so, are now eligible for reinstatement with back pay. That's still in the works. So how that's exactly going to be implemented, I don't know if Congress has appropriated funds to compensate individuals to this extent. So it's still to be determined exactly all the W's. Where are they going to go? When are they going to go back in? When are they going to get paid? When is this going to happen? It's on a case-by-case basis. Individuals who desire reinstatement should contact their prior unit and/or legal counsel to facilitate reentry to the military to ensure you're given your proper back pay, because you could be entitled to 6 figures worth of back pay. If you were kicked out in 2023 and you're going back in 2025 and you were a captain, you might be eligible for a couple $100,000 plus in unpaid wages. So there's a lot of logistics associated with that. Definitely want to have individualized attention, and the point of this program is to say, to my knowledge, the intent was to have an update here, but they have not actually published the implementing guidance of how they're going to do this, except for the fact that on a case-by-case basis, individuals will be notified of their reinstatement and then the new orders to the new assignment. But many people walked away permanently from the military. I think the majority probably won't rejoin or go back in, but the ones that wish to collect back pay, should probably do so. It's a real easy way to, potentially get a windfall and restart life. Abortion, travel, authorization, and reimbursement. So this is another thing that's being litigated. Previously, individuals were given authorization to travel specifically for medical reasons associated with bans on abortion. Now, in the United States right now, the last look I had, there are 13 individual states where abortion is completely unlawful under almost every circumstance. Idaho, Texas, and many other jurisdictions. Texas being probably the largest, most significant, impactful one, because it has over 100,000 active members of the military. If you are a member of the military in Texas and you wish to have an abortion, you need to leave Texas to have that lawfully. There are no lawful abortions occurring in Texas. So for a while under the Biden administration, if you needed leave to go to New Mexico or California to have this, you were given reimbursement and leave. That has been revoked, and travel reimbursement has been canceled. So individuals will no longer be eligible for leave pertinent for this particular purpose. So if you are a female and you don't wish to be assigned to these jurisdictions where abortion is unlawful, that is a consideration to take something to take into consideration when it comes to assignment preference. However, you may be forced to serve in locations that are not desirable. That's part of, unfortunately, I spent 8 years at Fort Hood, now Fort Cavazos. I don't know if it's going back to Fort Hood soon or not. They have changed Fort Bragg back to Fort Bragg, and Fort Benning is now Fort Benning again. I would anticipate further name changes, but I don't know what the status is on Fort Cavazos, but it's currently still Fort Cavazos to my knowledge, and those names are changing periodically as Secretary of Defense issues new name change orders. That's really the point here is be mindful of the fact that the travel allowances under the medical authorization for abortion have been canceled and rescinded. The media has not really talked about that to the extent I thought they would. They made a big stink about it during the Roe decision being overturned about 3 years ago. But since then, there hasn't been a whole lot of discussion on it. And most of these states that have enacted bans, they're now in effect, and the numbers are what they are. So move on to the next slide, number 9. Policy changes. As you saw, we're going to be focusing on different international conflicts around the world. There's ongoing war in Ukraine, which the administration is trying to wind down. Apparently, there's talks between both sides to try to facilitate a ceasefire. And at the same time, we just attacked the Houthis in Yemen with more aggressive intervention. So there's ongoing conflicts around the world at all times. Military focus will probably be more on deterring China and pulling out of Europe, but that's really outside the scope of this presentation. There's name changes to installations coming down. There's going to be more of the construction of an Iron Dome. They just talked about the new fighter jet called the F-47. That's going to be the focus of our defense systems and protection of the nation. And they've also deployed 2 military combat vessels to the coast off Mexico to interdict the cartels. So I'm noticing significant military mobilizations along the southern border, significant use of naval assets along the Mexican coast. So it appears that the administration may be focusing on potentially starting conflicts with the Mexican cartels and the terrorists in the Middle East. And the Israeli conflict continues tragically. So there's a lot of stuff going on in the world. Military is actively involved in many areas. There's been a lot of talk about potentially redeploying assets out of Europe and letting NATO, the countries of Europe, fund their own defense. That may result in assignment changes and the pullout of troops, but that takes time. That'll happen over a glacial pace. I don't foresee it happening immediately, but turn on the news because you never know what's coming down the next day. You really don't. Let's go on to the next slide. All right, there has been a substantial increase in recruiting numbers. Part of it may be associated with the current economic downturn that we're seeing in the labor market. Labor numbers are down, so every time you have a labor market contraction, military recruiting goes up. Other people's spin on it is now they're joining because they're patriotic and they want to serve under President Trump. There's probably truth to both of those. One, there probably are fewer job opportunities to some extent because the economy is starting to contract when it comes to the labor market, which has been robust for years. And as the economy contracts, people join the military as a form of economic desperation to try to put food on the table for their family. That happens all the time. Other times, people join the military for patriotism exclusively. I think you're seeing both at the current moment. And the armed forces is going to be, that'll tie back into my selection criteria discussion. As more people wish to join, they'll be more selective. At the current moment, the only branch that has continuously met recruiting criteria annually has been the Marine Corps. The Marine Corps also, because they meet their numbers annually, is the most strict when it comes to throwing people out of the service. I've experienced that in my own representation capacity as an attorney in private practice. The most difficult cases to win are generally against the Marine Corps. They're the least forgiving service. Why? Because they have an endless stream of people wishing to join. Their TV ads the few, the proud, the Marines. It's really, really powerful, and it gets a lot of individuals who are really wanting to be joining an elite group. Doesn't matter what the pay, they just want to be part of that elite group. So the Marines seem to never have a problem recruiting. On the other hand, the Army always has a difficulty because the Army is generally considered the least desirable service. I joined the Army for 8 years, so I can say that comfortably. Some people will disagree with that, and I shouldn't say that out loud, but truthfully, generally the Army is kind of the service where everybody goes, or everybody has, if you don't make it, the other ones. That's generally the Army's the catch-all. Nothing wrong with Army service, because Army service can be great and result in a great, longful, economic benefit. At the same time, it can be difficult and put you in installations and locations that are not desirable. Like, for example, the Navy is in San Diego and in Virginia, very beautiful locations. The Army's in Fort Polk, Louisiana, or Missouri, in backwoods, Fort Leonard Wood. Not exactly the most desirable locations compared to, say, San Diego or Miami, where you might find other installations and assignments. Like, for example, I just got back from Europe. Some people got some really, really cool assignments. Other people are stuck in the middle of nowhere, and that's, if you're in the middle of nowhere, you're probably in the Army. But that is outside the scope of any legal analysis, and not much you can do about that. What I want to focus on is a couple points here. Social media content. I have seen emphasis on cracking down on discipline for those individuals who are openly being hostile politically. So be mindful of complying with your restrictions under the UCMJ to conduct yourself in a manner that's not partisan. And if military service is no longer desirable and you wish to leave the military, you can contact an attorney to discuss your legal options. There's always available options to try to avoid continuing service. But recruiting at the moment has gone up. The numbers show that. Seen a lot of stuff in the news about security clearance revocations by law firms and other individuals. This is not a security clearance webinar, but we have done a significant number of those on our web page. I would encourage you to review each webinar when it comes to security clearances, because the criteria to hold a clearance is squeamish and it can change based on the moving characteristics. But generally, if you have blemishes, you can be removed from having access to sensitive information. The intent right now, based on the new executive order, was to try to get these clearances approved quickly and get them processed faster, and hopefully have individuals getting approved sooner. However, there's a concern with inadequate vetting and potential access to information by individuals who are not suitable. That's a topic for a whole different presentation, and we've done presentations on each criteria for eligibility and each area of concern where you might get removed. So, for example, if you have a foreclosure, if you have a bankruptcy, if you have a really nasty divorce, or if you have a really difficult drug use history, you might be ineligible for a clearance. Then again, if you have a condition such as mental health and it's being treated, you might be given a waiver and it might be considered okay because you disclosed it. But everybody's situation is different. Everybody's case is different. Everybody's unique circumstances have to be reviewed to determine eligibility, and it's a case-by-case basis. But the changes are fast and furious, and they're coming down at light speed. So we'll keep monitoring that and give updates as appropriate. Okay, move on to the summary here. Now, the intent here is to tell you that the courts, the most impactful, the most significant executive orders that have been produced, the ones that are huge policy changes, such as like the birthright citizenship, they're blocked at the current moment. The transgender ban, blocked. All the stuff that's had significant changes from the Biden administration, the federal courts have currently blocked. In reaction to that, the president, issued an executive order on Friday night saying lawyers that file frivolous cases will be referred for sanctions. That's kind of silly because federal judges decide the appropriateness of sanctions, not the executive branch. But the intent, I think, was clear that they're frustrated by the litigation because most of the executive orders are not actually in effect. The ones that are impactful, the ones that are permissible deviations in policy or changes, such as what web page you put up on your website, like the DEI stuff, that's happening, and that's not really subject to judicial review. Whether you promote water on your website or a tank, it's not really, who cares? It's legally speaking. There's no legal distinction between the two. You can promote whatever you want generally within reason when it comes to certain conduct and actions, and the courts really can't scrutinize it. When it comes to criteria for individuals' fundamental rights, though, the courts are involved and litigation is ongoing. So as your individual situation arises, you may wish to seek legal counsel to intervene on your behalf. And again, our firm, we have offices coast to coast, and we help individuals out on a daily basis. And not to sound braggadocious, but I personally have traveled to 47 individual states for this firm, to ROTC programs or federal courts or military bases. I'm only missing Montana, North Dakota, and South Dakota. And I intend to go to Montana soon, and probably the Dakotas next. And then I'll have covered all 50 states. I've also appeared in 9 countries where we have military assigned. So not just me, but my colleagues have also done the same and been all over the place. So we cover the world when it comes to members of the military. And if you're in Kuwait and you need help, we can help you out. If you're in South Africa, if you're in Brazil, if you're in Australia, it doesn't matter where you are. We have the capacity to assist you 24/7 and provide you representation regarding your military needs. And we have members of the military stationed in every country in the world where we have an embassy. So if you're a member of the military in wherever and you need help, feel free to reach out and we'll give you the advice and assistance necessary to try to get you sorted out. So at this time, I'm going to open it up to some questions. And I did see some questions earlier that were produced before, and I'm going to go ahead and try to answer those as I can, because individual questions are important, and I want to answer them to the extent possible. So there's been an executive order removing the criteria to give preference to minority-owned businesses when it comes to contracting. I don't know substantively what that's going to change immediately. It just means, some of that was disingenuous to some extent, because if you had a company like my uncle Bob, he had a company in New York that did gravel and cement, and instead of having his name as the owner, he put his wife, my aunt, as the owner. Why? Because she was a female, and as a female, she got access to female-owned small business loans and female-owned contracts and female this and female that. But the reality was all 19 people for the company were guys driving gravel trucks, and they got all the business through her, and she was just a figurehead on paper. And that's no longer the case anymore because they've retired and move on with their life. But the point I'm making is the question here is, will there be a change in who gets subcontracts? Probably not. What that basically means, in my opinion, and again, this is only my opinion, is you no longer will have to just, fudge the paperwork to show it's a female-owned business or a minority-owned business. You can just submit the request for contracting as is and see what happens. And the criteria should be based on capacity to perform the contract, no longer any distinction on who owns it. That's the intent behind the order as I understand it. Whether that changes who gets what, I really have no idea. I don't think it'll be a big change in who gets what, honestly, because if you have an existing relationship as a subcontractor and you're getting a contract, whether it's owned by whoever, probably doesn't matter as long as the company's doing the job still doing. But it will mean in the future, when contracts are awarded, you won't have to play these games anymore where we got to make sure we have a board of directors that, we got one person from Asia, one person from, India, one person from here, there, and everywhere to show a diverse team. You no longer have to necessarily do that in order to be eligible for access to these contracts. That's my understanding of it. Next question I received in written format was RIF for disabled veterans. My understanding is they're not really taking into consideration individuals' veteran capacity when it comes to removal for the RIF. Under federal law, my understanding is veterans are generally given a hiring preference. When it comes to reduction in force, that criteria is different. So when it comes to being hired, if you're a veteran and it's a position below a GS-11, you're generally given a hiring preference as a veteran. When it gets to a certain compensation level, though, veterans preference no longer really matters because it's highly compensated, so they don't give you an extra benefit as a veteran. For low-level jobs, GS5 or something, you might get a preference as a veteran. And that might be the same when it comes to keeping you on the payroll for removal. But RIF criteria is going to be agency by agency. So if you have specific questions about reduction in force and the impact it might happen on your individual employment situation, I would encourage you to set up a consultation with one of our federal labor and employment attorneys to discuss the pertinent facts specific to your situation. I do not believe disabled veterans will be given any priority preference for keeping their job. I do know that if you're a disabled veteran, by law, you're entitled to a hiring preference when it comes to acquiring the job. But keeping it, that's a different analysis. Impact on affirmative action programs, MD 715 filings. That's a little too nuanced for this webinar. I would encourage you to seek an appointment with an attorney to do some specific research. I will say that affirmative action programs at the federal level have been abolished. In 1965, President Johnson signed the executive orders for implementing affirmative action. They were in effect for 60 years. One of the first executive orders the president signed was abolishing affirmative action. Actually just completely canceled the existing order that had been in place for 60 years. That is a significant and radical policy change that was talked about by President Nixon, President Reagan, President Bush, President H.W. Bush. I mean, I remember in the 1990s, in 1996, that was a big campaign issue that Bob Dole ran on. Bob Dole said, I'm going to ban affirmative action. Well, Bob Dole lost. Bill Clinton won, and the issue died. Well, President Trump ran in 2016. He didn't touch the 1965 executive order. In 2025, though, on his second administration, they did, and they have effectively, at the federal level, removed affirmative action as a mechanism for awarding contracts. So, and again, that's just a policy decision. So I'm not sure the lawfulness of that, and there may be litigation associated with that when it comes to the existence of ongoing contracts. But my understanding is the executive order that President Lyndon Johnson signed in 1965 that established a federal program for affirmative action has been rescinded, meaning it's canceled. So that's significantly impactful, because if you're relying on that program to be available, it's no longer there. So you'll have to find other criteria to be awarded the program or awarded what you're looking to seek. Also, I got a question about ongoing hazing occurring in the military and, fraternization. I will say this in response to that question: there's lots of misconduct in the military every day. Just for example, for the last 100 years, driving while intoxicated has been unlawful. Yet every day, my police officer neighbors tell me about how they had arrested somebody for driving intoxicated. So my son plays baseball, and some of the fathers on the baseball team are police officers in the location here in Houston, and they're always talking amongst each other about arresting drunks. The point is, no matter how much we've banned driving while intoxicated, no matter how much we've established Uber, established Lyft, established buses, taxis, mechanisms to avoid driving while inebriated, it still happens every single day. Why? Because human behavior is very predictable. So 3 things we'll probably never get rid of is drug use, sexual inappropriateness, and alcohol abuse. It's just human, in my opinion, again, I'm not speaking for anybody other than myself, it's human nature to do stuff that's not okay. And it happens indefinitely. So it doesn't surprise me that your son is seeing investigations for hazing and fraternization and psychological torture and other terrible things. It's not supposed to happen. It's not okay. But again, human beings are involved. So is there going to be fraternization and hazing? Yes, it's going to happen. In response, there should be an investigation and punishment for those who are responsible, and individuals should be, given remedies associated with what they experienced. So if you are a victim of fraternization or a victim of hazing or a victim of psychological torture or other misconduct, by all means, there's mechanisms to seek help. There's the Inspector General, there's the Article 138 complaint process, there's the 1150 complaint process in the Navy, there's congressional inquiries you can establish, there's hiring counsel to intervene on your behalf, there's seeking open door resolution with your command. There's lots of things you can do about it in response. You don't have to just let it happen. You can blow the whistle and hopefully it stops. But it doesn't surprise me one bit that your son or daughter is in a unit where this is happening, because it happens all the time. It's quite scandalous how much misconduct occurs within the military. But again, you take any group of 100,000 people, and within that group, you're going to have a percentage that is bad. It's like a batch of apples. You're going to, or a box of eggs. You might have a broken egg in a carton. Doesn't mean the rest of the eggs are bad. It just means that one broken one you can't use. Well, the same thing with the military. You're going to have deficient individuals who get through the selection criteria, who join, and then some of them will acquire rank and status, and then they'll make other people miserable. And that's unfortunate, but it happens periodically. The response then is to try to rectify the situation and correct and get rid of the toxic leaders that are harming others. But sometimes it goes on for a long time before anybody does anything about it. So retirement impacts. There may be some eligibility for early retirement. I know the military has done that frequently when they do a drawdown. So if they do a reduction in force, they'll probably open up retirement eligibility down to 15 years. But I haven't seen anything come out that right now. Impacts to contractor support. Yes, there's been a significant number of cancellations when it comes to individual contracts with NGOs, non-government organizations. USAID is a great example. They gutted the program, meaning most of the contracts were either rescinded or canceled, or some of that's on hold. A lot of that's subject to litigation, but I do see going forward in the future the number of contracts being awarded significantly impacted by budgetary restraints. The country is running a large deficit, and Congress and the president have indicated they want to reduce the deficit and they want to pass tax cuts. They're going to obviously cut programs that exist in order to move money around where they want to redirect it to. So yes, I do see a lot of changes coming down the pipeline, and a lot of changes are going to happen even with the budget that just passed, which Senator Schumer is facing a lot of blowback for allowing to occur. So there's going to be a lot of changes forthcoming, subject to another webinar. I believe over the summer we'll probably do another update to see where these cases come out. I was a little too aggressive in having another update just a month later. I think we'll come back in 6 months and see where things stand and what the landscape looks like at that time. We'll have a better idea of what changes to the armed forces have occurred, what's going to continue to happen, what things look like for your legal rights and remedies, and what you can do in response if you feel you need to respond accordingly. At this time, I've answered all the questions that were submitted in written format. If there's any other questions anybody has, I'll open up the floor to questions. All right. Brittany, do we have any other questions?
Not any questions that be relevant to the Department of Defense.
Okay. Well, if you have other questions regarding other areas of the law, you're encouraged to join our team here and call us. My contact information is provided here. You can reach me at 832-241-5888. You can also send me an email, any feedback you have, as Timmons@tullylegal.com. And I welcome all feedback, positive or negative, because you get better with things as you receive negative feedback, honestly. So any criticism, I'm happy to take the arrows as they come in. I actually enjoy it because it reminds me I'm still here, taking incoming fire for others. So please send any feedback you wish through my email address, and I'm happy to answer any questions people have through a consultation. If you want to book an appointment to answer your specific legal questions regarding your pertinent legal need, happy to do so. And again, thank you for listening into our discussion, and be mindful that the policy changes are happening on a day-to-day basis, and the courts are actively litigating these cases as we move forward. So things are really in flux. And I have not seen things in flux to this extent in my entire legal career. And I've been an attorney now for 17 years. So I'm sure people going back 30, 40, 50 years may have seen a similar change of pace, but I believe this is the biggest departure when it comes to policy changes we've seen in an administration, because the consensus, for a long time is now the current policies being implemented are quite different. So we're going to see significant changes as we move forward, and we'll try to keep up with it and help everybody out along the way as we can. Thank you.